Good afternoon, everyone, and I guess for those on the West Coast, it's still morning. And welcome to another webinar from Duke EDRM entitled Avoid Surprising Litigation Discoveries, Leveraging Tech for Complex Litigation. My name is Jim Waldron, and I'm the Director of EDRM at Duke Law School. Today's webinar is sponsored and produced by TCDI. A quick note and some background stuff as far as Duke is concerned. EDRM at Duke Law School creates practical resources to improve e-discovery and information governance. We aggregate member individuals, law firms, corporations, government organizations, and the judiciary to actively contribute to the direction of EDRM. And to quote an oft-used phrase, we want you, we need you, and hopefully you will find this content worthwhile and want to be engaged and get involved with EDRM at Duke. It's through your widespread participation that we're able to represent the landscape of e-discovery and information governance. We prefer our webinars to be interactive, and we like your questions. Please make sure that you engage us with questions, and you see the question box at the bottom of the page. We'll monitor those questions and get to them as much as possible. So one quick note about what you would do if you got involved with EDRM. We have several projects, actually I believe it's 9 that are ongoing. Most of you probably know about the TAR project that's going on. We have an EDRM revision, which is the EDRM model is being updated. We have the GDR project, which is GDPR project, which is working towards developing a code of conduct for cross-border discovery under the EU General Data Protection Regulations. We are revisiting our information governance reference model, which has not been updated. We have an interesting team of people. We're doing a session on proportionality, stop words, and privilege logs. And I believe I've got one more. No, we have several more. We have artificial intelligence, which is obviously an emerging trend in e-discovery, and maturity assessment, which is the project's goal in that one is to develop an interactive tool to measure a company's e-discovery management based on the EDRM maturity model that we developed a while ago. And we have quite a few people involved. We welcome your participation in any of those projects and hope that you will consider joining us. Please visit our website at edrm.net. Now I'm going to introduce Tim Opsenik, who is the Vice President at TCDI, and he's going to be our moderator today. So Tim, I'm going to turn it over to you so that you can introduce the rest of the panel.
Thank you, Jim. Thank you for that kind introduction, and thank you to EDRM for hosting this for us. Today we have 3 experts on our panel. Kara Landry, who's the President of the Litigation Services Division of TCDI. We have Ellen Gregg, who's a partner with Womble Bond Dickinson. And we've got Mike Klein, who's the Assistant General Counsel for Altria. A little bit more detail about Kara. Kara brings over 20 years of e-discovery and document review experience to TCDI. In her role as President of the Litigation Services Division, Kara oversees workflow creation, service delivery, and development strategy for our processing, hosting, review, production, and litigation management applications. Kara's expertise in building new platforms aligns closely with TCDI's strategy to increase innovation and improve workflow. Her diverse operational experience and hands-on approach with clients is key to continually improving the TCDI user experience. Ellen is a veteran trial lawyer. Ellen leads the case management facility at Womble Bond Dickinson, which helps clients manage information in mass tort and class action litigation. So she is had a great deal of experience with litigation management, as we'll hear later. Ellen is also the vice chair of the firm and is an innovator in the law firm's leadership, professional development, and recruiting programs. Ellen has litigated cases at all levels of state and federal courts, including class actions, medical malpractice, wrongful death, civil rights, and complex liability claims. Ellen applies this experience in her role as team leader at the CMF, a high-tech legal knowledge management system. The CMF creates and administers case repositories and virtual law firms nationwide, enabling in-house and outside counsel to communicate in real time in a secure electronic environment, to instantly access all your work product and to reduce costs. Her recent efforts focus on applying business intelligence and predictive analytics to her clients' litigation. For years, Ellen has helped her clients achieve significant budget savings while enhancing their ability to win cases. Last but certainly not least, Mike Klein. Mike manages a team of 25 staff people, which provides a full range of litigation support services for the Altria family of companies. He is also the Director of Records and Information Management, and thus responsible for managing the policy, training, and communication requirements for Altria's Records and Information program. So today we're here to talk about complex litigation management, which is no easy task, and managing the growing amounts of data from different teams can seem impossible. Today we will discuss how a litigation management tool can help manage multiple cases, provide visual dashboards that ease litigation management, provide the ability to visualize your data and create clear and persuasive charts and graphs to tell your story. Today our panel of experts will share their strategies and experiences regarding litigation management. So today we are our agenda, we will cover the problem, the solution, and where do we go next, all related to litigation management. I would encourage questions. We do and will see the questions. If for some reason I don't answer your question right away, it's probably because I think there's a time that will be where your question will be better served, where we may be talking about exactly that topic, and I may withhold your question until that time. But as Jim started out by saying, we certainly encourage questions, as that will help move things forward. So first, the problem. Litigation management is a very confusing term. What exactly do we mean when we say litigation management in the context of our discussion today? Let's start with Kara.
Thanks, Tim. Litigation management, as Tim said, it can mean different things to different people. We are going to talk about it from a legal perspective. And loosely, it's a means of organizing large amounts of information associated with either active or potential litigation. It's a way to organize and centralize all the disparate case materials so that case teams can be as efficient as possible and information can easily be found. Litigation management technology, then, is the tool that allows for that centralization and organization. And just generally, that's a baseline for what we're talking about today.
Ellen or Mike, anything to add in terms of the description of litigation management form at 10,000 feet? Later we're going to talk about some of the essential attributes, but anything to add to what Kara mentioned?
I think Kara handled it very well. Thanks, Tim, for asking. I think that each client and each law firm has to think about litigation management from the perspective of what each of their clients are trying to achieve, and you're going to hear more of that in the rest of these slides.
Excellent point.
Okay, so Ellen, or before we get into that, when, if at all, should you consider implementing a litigation management system? In other words, what litigation circumstances am I experiencing that suggest that I need it? Ellen, would you like to talk about multi-district litigation first?
Sure. Multi-district litigation is probably the banner situation when you might need a sophisticated legal knowledge management system. For those who are familiar with multi-district litigation, you know that by definition it means high volumes of the same kinds of cases, same issue, repetitive issue cases that are consolidated in federal court for purposes of discovery and other proceedings, because the sheer volume of the cases and the sheer volume of the litigation would be such a struggle for the judicial system to support if you looked at them from an individual case-by-case basis. So multi-district litigation is a wonderful example of when a legal knowledge management system is appropriate, but it's not the only one. As the slide shows here, some other flags for you that you might want to consider, that if you've got litigation and you've got a large or diverse portfolio of cases or claims, you should consider implementing a legal management system if you've got a joint defense group where you have more than one defendant operating under a joint defense agreement with multiple case teams, or whether you have a large catastrophic event that leads to a large number of same issue cases. Complex class actions that are long-term litigation and complex litigation are excellent opportunities there, as well as large government investigations and regulatory investigations. In general, if you have a lot of law firms involved, or a lot of cases, or a lot of plaintiffs, I tend to be on the defense side, so for those of you who are on the plaintiff side out there, if you have a lot of defendants or large defendants and a large number of parties, you probably should consider a litigation management system. But let me just make my point a little bit, bring it right down to a more specific point. If you have a lot of Excel spreadsheets that you're using where you're tracking a lot of data and information about your cases, and if you have law firms that are swapping off a lot of Excel spreadsheets, or to give you a specific example that I encountered once with one of my clients, if you walk into a meeting and say, who has the chart of the cases, and someone walks in with a printout that is hundreds of pages long on oversized paper that they had to queue to the printer the night before because it's that long a list and it's that difficult to keep up with everything, you probably need a legal knowledge management system.
So Mike, I'm going to single you out here for a second. One of the topics here is long-term litigation, and one under the companies of Altria includes the Philip Morris companies, and I think I seem to recall the first product liability cases involving Philip Morris were somewhere around 1958, and so that means we've had about 50 years worth of litigation. So I think that qualifies as long-term litigation, so I wondered if you have anything to add here.
No, I think Ellen really hit the points, and we are indeed the I think paradigm long-term litigation company. We have been in product liability litigation for decades, and those cases tend to be very similar. There are certainly factual matters that vary from case to case, which is why so often they're not amenable to class action treatment. So they're just turn out to be thousands of individual cases because of factual differences, but the kinds of work that is done in any one of those cases, it tends to be very similar over time, and so the efficiencies that can be derived from a litigation management system are just tremendous, and we'll talk more about it, but we've been certainly a big believer in the power of litigation management for decades now.
Anything else on that topic? All right, so let's talk a little bit about the solution. How does litigation management technology help? And so, Kara, let's start with you.
Yeah, so the slide that we're looking at now, we often feel that it's helpful to visualize exactly what litigation management technology is doing. Ellen and Mike both talked about, lots of different law firms, lots of different document types, long-term litigation, getting it all in one place. Having that ability to centralize all of that information. I mean, the example Ellen gave of that single document, walking into a meeting and being asked for that, to look at that one document. Historically, when you have lots of different firms accessing, they use their own proprietary technology or in-house technology. They use whatever their favorites are, and data is just everywhere. So choosing to use a single litigation management tool, centralization is key. It brings all of that information into one area. You know where it is. You know how to find it. If it's the right type of tool, it's going to be easy to find it, and it really will promote collaboration. But additionally, it will reduce rework, multiple firms doing the same thing. It will reduce spend for that very reason, but just having everything in a single location makes it so much easier to know what you have going on and where it is, and to do trend spotting and to do data analysis just in the single platform. So what we're looking at now are, the essential characteristics of any litigation management tool. That centralized repository, you know where to go to get it. Case team collaboration, you load all of your pleadings, your transcripts, your exhibits. You load a central case calendar where everyone can put their event dates. Just having that all in a single place with automated reporting, dashboarding, that total case access, and then increasing efficiencies. We're going to take a deeper dive into each of these, but these 6 things are the core characteristics of any lit management system that you would be using.
All right, let's start with that deeper dive and talk about centralization.
Yeah, so for centralization, we've really hit on this for the last couple of minutes, but it really can't be emphasized enough. Having that single location where you can organize data so that it's easily found, so you can organize data so that people know where to go, know where to put it. If you have visualization embedded into the platform that you're using, that's even going to make it easier for them to point and click and find what they're looking for. But again, I can't underscore the importance of that one-stop shopping, of having all of the data located in one location.
Yeah, and I'd add here is, it's intuitive, right? This is really no more than an electronic filing cabinet, right? But in the modern practice of law, certainly it's the case with Altria, we're very much about, maximizing the talent and the value we can bring to any given case. And so it's not necessarily the case anymore, like maybe it used to be, where we just hunker down with one law firm. We do what we consider, the virtual law firm approach, where we have tremendous legal talent spread across a number of law firms, any one or more of which may be working on a particular matter. And the fact is, you can't keep a physical file cabinet with all the important documents in one of those law firms, because the other lawyers wouldn't be able to access that information. And so this idea of a central repository in the modern practice of litigation, I think, is absolutely critical if your goal is to bring the best solution to bear at the lowest cost. You've got to get out of the siloed law firm approach, and the best way to do that is to force your legal service providers into a shared repository where they're all working out of the same place with the same information towards your ultimate goal, which is winning your case.
And Mike, I'd just like to add to one point you just made, which is working out of this repository. It's more than just a file cabinet, and if you plan well and you think proactively throughout the life cycle of your cases, this repository becomes more than just an online file cabinet. It actually becomes a tool for each of those law firms and each of those people assigned to your cases to do their work. The title of this program is actually Avoid Surprising Litigation Discoveries. And perhaps one of the greatest strengths of having a strong central legal knowledge management system in a large-scale litigation context is it's actually a function of risk management, because your lawyers can avoid creating dangerous inconsistencies in their work product by having access to others' work product and real-time knowledge of what's going on in other cases, in other jurisdictions and such. And so it's actually a tool to align people and best practices and technology around your strategy to win the cases, and it's a tool for them to actually use to create that next work product, to create draft pleadings, to create draft motions, and to actually create new work product, reusing the old and of course saving money, but advancing strategies and using the collective knowledge of your best lawyers to make all your lawyers work at the highest possible level.
Yeah, I want to echo that point, because I think the one thing that really rings true to me, Ellen, is the idea of consistency. As I think we've both experienced, we literally have trial teams in courtrooms in different locations at the same time on the same day. And it's really critically important for them to be able to have a sole source of information from which they can learn, and I think real time is the right word. That's not an overpromise. In real time, what their colleagues are doing in like matters in other courtrooms within similar jurisdictions, because the consistency piece, from an overall legal strategy perspective, is paramount.
Ellen, if you would talk a little bit about reporting and tracking, and then the dashboard slide, which is after this.
Absolutely, and this ties to the real-time point that Mike and I were just making. Your litigation management system supports a lot of the reporting and the tracking tasks that everybody has to do, whether you are the client in the company having to keep up with your portfolio, or if you're the law firm trying to keep up with your deadlines. Having a robust, what I'll call reporting and tracking tool in your system is critically important. To be able to run a search in the database and get a list of all the deadlines that's current, to get a copy of a report of all of the cases that are in a particular jurisdiction. This is a fundamental, foundational element of any legal knowledge management system, because if you can't keep up with your cases, how many there are, where they are, who's working on them, and be able to, quite frankly, with a very simple push of a button, get a report that you can turn over to your insurance carrier or an MDL judge, or to use to create your Securities and Exchange Commission filings quarterly or annually, or to insert into your shareholders report on your litigation report. It's getting the information out is foundational to it. Now these days, for purposes of many of those reports, pictures really are worth 1,000 words, because nothing conveys size and significance as much as a visual. If you look at a bar chart and you can see a really long orange line across one category, you know where your resources are focused right now, you know where your priorities are, and you know where your deadlines are. And so you can budget and plan better because you have the ability to both report out and give that visual impact of the value of that data out of the system. And current systems like the TCDI system gives you the option of just running a report that would be a printout that looks like perhaps an Excel spreadsheet that you could manage, or in this very system you can create your reports with very nice visuals. My team regularly uses TCDI's system, and we use this to create PowerPoint slides for folks to use in-house to report up the chain on how many cases, where the cases are, who the law firms are, and as I said, you just can't substitute for a visual that makes the impact of the metrics.
And
So Kara, go ahead, Mike.
Yeah, I was going to add, Tim, Ellen has tremendous experience on the law firm side of this. I'm on of course, the client side of this, not Ellen's client, but we certainly have worked together in the past in a joint defense agreement circumstance. What the importance of these tools, and we also work with TCDI to provide our litigation management solution. the importance of these reporting tools for the day-to-day conduct of in-house business is it's hard to overstate. I know regularly the output of this system in terms of reporting and charts and visuals are used at the C-suite level on a weekly basis and become parts of board presentations. That's how impactful this information is and how easely it's aggregated and presented, that it literally, in my experience at Altria, becomes part of the senior-most decision-making process within our company.
So, Kara, next we want to talk about the what you mean by holistic case access. What does that mean? And if you could share some stories and thoughts on this.
Sure. So what we mean by this is, when you're centralizing the data, you have it all in a single repository. Everything Mike and Ellen were talking about, the benefits, the pros, how people are using it, some of the stories that they told. One of the key important issues for any centralization repository is that you're not always going to have power users. Not every user is going to be a sophisticated technological user. Maybe they've used Excel or PowerPoint. Maybe they've used an e-discovery tool before, but they're not all going to know how to run complex searches or what Boolean means or how to run a SQL query. So simplifying it and having it accessible in as easy of a form as possible for people to access their information is key. So when you're looking for a litigation management platform, you definitely want to look for ease of use because you have to think about your audience. So what we're looking at, we have access to our own platform, which is TCDI, so that's the screenshot I can share with you. But, being able to relate or link all case materials to a single click or to a single picture or to a single graph that's interactive makes it so much easier for people to access their material. So, you find your case either through a search or maybe you do filtering, maybe you choose it from a lookup list. Maybe you pull up a dashboard and that orange line that Ellen was talking about that was much longer than everyone else's, maybe you just double click on that and it will filter and do an immediate search for you because everybody can look at a picture and click on the part that they're interested in. That doesn't take technical know-how, that just takes a mouse or a finger. And once you do that, it brings you then into the case, and once you're in the case, you don't want to, again, have to run searches, so having the case materials, so the case documents there, having the plaintiff list, having the fact sheets, having the depositions and transcripts all within one click and accessible, that's key to your litigation management system. So again, I highly emphasize looking for platforms that emphasize ease of use. Which,
Kara,
sorry,
excuse me.
Yep.
This is, I just wanted to add here, I'm sorry, on the holistic case access point, I want to highlight an area where I have seen mistakes made when it comes to legal knowledge management systems, because one of the really great aspects of technology is you can create this database and you have all kinds of security options where you can give your users access to what they need, and you can lock things down, and you can have security models that work to protect whatever the client's interests are. And one of the big mistakes that I have seen that people make is they are a little too generous with their security systems, meaning they lock things down too tightly. To cut to the chase, they tend to only let the lawyers look at the cases the lawyers are actually working on. If you have 50,000 cases and you have lawyers in 50 states, your lawyers in each state should be able to see, subject of course to privilege concerns or protective orders, the more your lawyers can see of the other great work product, the more value you're going to get out of this system. And so one tip I have for you is go broadly on that security access, because if you as a client are controlling this, and these are all your law firms, it's going to help advance the cause and help you win your cases, and your case strategy will be stronger if you are a little more open with your security model among those law firms that are within the privilege, so they can have that holistic case access and have access to that collective knowledge.
And so I'll chime in as well and give you the other side of that coin. And I agree with that, what Ellen's saying. Absolutely. Let me address it from the client perspective. However, from the client perspective, I want this tool is one-click easy. I know that because my team is in it every day, as are hundreds of lawyers and legal professionals that are in the firms that use it. But I want super users. I want the people who are most proficient using it, because with every user there's a potential cost, right? Not only their time, but there could be other costs associated with the use of the tool, whether it be licensing or things of that sort. So I think there's a balance to strike in terms of having the smartest, most prepared lawyer you possibly can. You want to keep it broad. If you want to make it as efficient a tool and as cost-effective in your litigation from the client perspective, you're going to want to narrow that somewhat. But the beauty of these tools are, at least certainly the ones that Ellen and I have experience with using day in and day out with TCDI, is that you can calibrate it to whatever your needs are. You can lock it down if you need to for a particular matter. You can open up the access in another instance, and all the while getting real-time feedback in terms of what the system is doing, who's in it, and what it's costing you to operate.
So, Kara, back to the next slide. If you could talk a little bit about when you talk to clients, what do you tell them that they can expect to get out of litigation management technology?
Yeah, so I'm sure by now everyone's read the slide. These are the high points. You know, we talk about how to reduce the overall total cost, because from a litigation management perspective, that's something that we're trying to do. You know, from data intake through to legal spend analytics. We're trying to have that one location where, you know, in-house counsel or law firms can manage the overall process and then the overall spend. So we do talk a lot about overlapping tasks and redundancy. We talk about, you know, we give them a day in the life of multi-district litigation or complex litigation, where you've got multiple firms basically doing the same task but in different systems. So centralizing that's going to reduce that work and the overall spend. Everything that the loading into all those different systems, that's going to be reduced when you centralize. The processing of data is going to be centralized. And really some of the key facts are things like case strategy. If you don't have all the data in one place, centralizing it is really going to optimize your ability to do that. Data management in the system is going to give you access to all the data points. It's going to give you access to all the cases you have in there. It's going to give you access to all the different case material and the facts that are important on each case. Plaintiffs, dates, activities, events, all of that is going to be in a centralized location. So when we showed dashboarding and when we showed reporting, you know, Ellen mentioned, you know, being able to create those powerful graphics or those powerful reporting metrics. I mean, it's going to change the way that you approach litigation. And so those are the key things that we're hearing from our clients. Mike, it would be great if you could tell us, you know, what are the, you know, top one or two things that you get from the litigation management platform, like when you're talking to your outside counsel. How are you getting them into the system?
Yeah, I think the, you know, because we are a perpetual litigant and have been doing it for decades, one of the things that's incredibly helpful is understanding over time what company positions have been in litigation, either through company fact witnesses or through expert witnesses. And you know, if you're in a traditional law firm setting, you know, over the course of 20 or 30 years, those files can end up in different places, in different drawers. People come, people go, and it's hard to sometimes recreate what has gone on 10 or 15 or 20 years before. When it's all in a centralized litigation management tool, you don't worry about that anymore. And I can answer, and I do on a daily basis, queries from our outside counsel as to where we want to go in thinking about this next case by pointing to where we've been over the course of many years on a similar issue. And I'll just remind them that they have that all at their fingertips because all of my key litigation attorneys and their staffs have access to the litigation management tool that we and TCDI provide them. So I think that is, to me, an everyday reminder of how powerful this tool is that it's a in one place a historical record of things, not just for history's sake, but things that matter today.
So
And then,
I'm going to ask,
and then,
go ahead.
so I was just going to say, and then Ellen, I mean, I'd love to hear your perspective from the law firm for your clients, your corporate clients who aren't using a litigation management platform or who aren't pushing you to use one. What are the selling points from your perspective? What are the big points that you tell your clients, the impact points that they'll have using this type of system?
Well, I won't repeat all the great points you've already made, because especially about cost savings and return on investment and such. And Mike, I think your point on consistency and finding the historical trends in the information and just the evolution of the company positions and evolution of testimony, all of those I agree with, and we talk about those. But a couple of other random points that clients have told me that they have found, that I have found resonates with new potential clients, is these kinds of systems actually help clients, my in-house clients, save money because they don't have to devote additional staffing in their general counsel's office. They can save on paralegal positions, some staff attorney positions. We have found anecdotally some information that having a system like this actually reduces the number of law firm timekeepers on billing for these matters for these clients, because this system gives the information at the touch of a button, and you don't need additional paralegals or additional young lawyers doing research in matters. It's already there, and so you don't need the additional timekeepers for that. And the last point I'll make on this is one particular client documented and reported back to me that it actually reduced their out-of-pocket expenses, reimbursements to their law firms, not just billable time, but it reduced their out-of-pockets by something like 35 or 40% to have this system, because each of their law firms was maintaining different, they quit maintaining systems and having pass-through costs and expenses and such associated with the litigation. So I think there are some real in-house savings in addition to the other more substantive points that Mike made there.
Yeah, that's a great point. We are all accountable to budgets, and Ellen and Mike, any additional information that you could provide on how you might quantify to a procurement department or others who hold you accountable to justify this spend in terms of a return on investment would be helpful. Any other stories, any attempts that have been made in-house by or by the law firms to quantify that is something that we often get asked for, and would like to hear if you have any other stories in that regard.
Well, I can offer one, and it's not, this is not going to be a blinding flash to anybody who's either in-house or in a law firm, but billing codes have been in use now for quite some time, and so you have a pretty granular sense of what the costs are in any given litigation, from the discovery costs to administrative costs to substantive legal work, and so I actually think it's quite easy today to make the case to your CFO or to your general counsel as to why this is a wise investment, because you have a wealth of data in your legal billing system that you can go ahead and rack and stack in a lot of different ways to demonstrate the various component costs of the litigation effort. You compare that to what has been my experience in having gone through several RFPs over the course of many years to initially decide on the tool that we were going to use, TCDI's tool, and then ultimately to reaffirm for ourselves that it was the right tool. It's, there are competitors out there in the marketplace, and they will provide you a pretty clear vision of what the proposed, yearly, and depending on what your contracting appetite is, what the spend is going to be over any span of time. And so it's really just it's an apples to apples comparison when you can point out the kind of work that will be foregone in terms of these different codes and the different spend that you can document you have incurred to date, and you can then match that with the kinds of things that this tool does that will eliminate the need for that work. And it to me, or at least in our experience at Altria, it wasn't even it wasn't a philosophical discussion. It wasn't something about, well, maybe and gee, if. It was just very black and white, quantifiable, that this was going to be a clear win. And of course, after a year in the system, and then 3 years and 5 years, we were able to go back and show tremendous savings. I mean, just tremendous savings, because now multiple law firms, and I'm talking dozens of law firms that support our litigation, aren't doing the same thing over and over again and billing us for it. So for us, and I suspect for any litigant like us that has thousands of cases that they're having to manage, it's not hard to make the case for this kind of a tool.
Ellen, what's your? Go ahead.
Oh, sorry, it's Kara. I was just going to, Mike made a good point about, going out and talking to providers in the market who are providing litigation management technology and, getting competitive quotes and going through that. Tim, you had asked me before, what are our clients coming to us for, or what are they asking for from litigation management? One of the things that I will caution the people on this call who are looking for a litigation management solution, just be on the lookout for the differences between an e-discovery platform and a litigation management platform, because we do have quite a lot of corporations and law firms coming to us after they had struggled through trying to make an e-discovery platform a relational database, which is really one of the key strengths of a litigation management platform, the fact that you can link together related information, and that's the relational aspect of it. It's really powerful to be able to link transcripts, exhibits, plaintiffs, fact sheets to a case, and that's not something you can traditionally do in an e-discovery database. So just when you're out there talking about litigation management, looking for a solution, just make sure that you are asking the questions about linking and relationships so that you're getting the platform you're looking for.
Ellen, what's been your experience? Okay, Mike, go ahead. I'm sorry. I'm jumping the gun. There's a bit of a delay here.
Yeah, I'm sorry, Tim. I was just going to, I think Kara's absolutely right, and I can tell you we have a separate e-discovery system. In no way can it do, and believe me, we would have done it if we could because of the, the cost savings that we could have, imagined. There's no way that your e-discovery system will do the things that you need to do in a case management system.
And
Ellen,
on that point, let's just admit that we're lawyers here, and the types of information that will be in your litigation management system versus what's in your e-discovery system, one is discoverable, one is not, and you want to protect the privilege on what's in your litigation management system because it is effectively your lawyer's attorney work files online to advance those strategies, as opposed to your e-discovery system, which is largely your corporate documents, which you are culling through, and they are largely discoverable but for anything that you're going to declare privilege for. So foundationally, that's a bright line that you have to be aware of. Tim, I think you were going to ask a question.
Yes, Ellen. What's been your experience with the cost of these systems, maybe on a monthly or an annual basis, and do they really pay for themselves?
Well, first of all, in my practice, we use a fair number of different kinds of these systems, and I will tell you that the price of the systems can be as wide-ranging as the litigation we've talked about. It literally could be one large case that's a class action versus 30,000 MDL cases. And so if you're looking on the market when it comes to cost for the technology platform, it's all over the board right now, and you get a lot of what you pay for. You get a little bit of what you pay for, and there's like I said, there's every month it seems there are new opportunities and new options that are launching into the market. That's no surprise. A new technology, different approaches. When you are thinking about cost, you really need to think about some of the other points that we've made earlier in this presentation, which is things like you want that holistic case approach, and you're going to have to get those materials in, because even though technology has advanced nicely, there's a fair amount of work that it takes to put these systems together and to actually get the information and the attorney case files and the documents and the data out of those documents. It's not just an online file cabinet of pleadings and transcripts. We also typically maintain separate, I'll just call them database tables, of information about the cases, demographic information. Could be demographic information about the individual plaintiffs in your 140,000 plaintiffs in 35,000 cases, which is a real example of what we had in an MDL litigation. You're also keeping up with manually deadlines, key deadlines that are in the cases. A fair amount of work can be automated, but not everything can. So part of the cost of this is the work by typically paralegals or very junior lawyers to make certain that what's in the system is timely entered into the system. Another best practice that we have learned is that if you really want it to be real time, you need to make this somebody's daily job to do, instead of just asking your outside counsel or your law firms to fit it in with what else they do. It falls down the priority list. And so when you're talking about cost, you have to think about the platform, the people that have to put the information in, and then that is what you compare against your return on investment. So I've seen systems where it's a client and we've got one or two paralegals here working on it for them very aggressively with very budget technology. We have other clients where it's a team of dozens of paralegals working on tens of thousands of cases. I think the overall cost is going to depend on the cost-benefit analysis that plays into your litigation goals. Now, let me just say that people like Mike and some of my clients that somehow are constantly in the litigation business as well as their primary business that makes money, we have some clients that will have litigation come and go. And so setting up a litigation management system like this is something that can be a cost that's turned on for a while and then turned off when the litigation goes away. An example of that might be a catastrophic event where the litigation really winds up very quickly in a large number of cases, and then over a period of 3 or 4 years winds down. Typically those kinds of cases are positioned early to be settled, and a system like this is a gold mine of information for helping manage towards settlement goals, especially global settlements and very large scale litigation. We had one client tell us once that our system, and it was more than 100,000 plaintiffs and cases, that within 6 weeks of the statute of limitations running on that mass of cases, because we had a robust knowledge management system that tracked all the plaintiffs and all the cases, within 6 weeks of that statute of limitations running, they had the information that they needed to be able to create a global settlement for those cases, and they announced it 8 weeks later. And so it was a key part of the settlement strategy because they had the data they needed to know exactly where the cases were, how many people were involved, what the damages were, what they might be, and so it really drove to their strategy. So from a standpoint of cost, it can be an ongoing cost, or it can be a thing that's necessary only for the scope of the litigation, and then you turn it off and it's not embedded in your law firms and it's not embedded in your in-house staffing either.
Mike and Ellen, what might you do differently next time? Have there been any negative experiences with litigation management technology?
So I'm happy to start there because we've been through a couple iterations of using the litigation management, and in the first incarnation of our use, what we didn't stay on top of was, and we didn't put governance around, was the fact that these are really, although they're based on some core technological architecture, they're very customizable. And when you have hundreds of lawyers and legal professionals working in the system, and they become very proficient at it, they start identifying idiosyncratic uses for the tool. Completely legitimate from their standpoint, like, it's the nature of human beings, right? We all do things and see things and think about things a little bit differently. But if you don't have some governance around these tools early on, and you're just hard pressed at trying to stay up with all the cases and win as many of them as you can, you may not be tracking all of the customization that is useful to one or two here and one or two there, but overall grows the tool into something that is much less logically constructed than it was initially. So when we went through a second iteration of this, we put some real strict governance around the use of it by our outside counsel and the others who were in the tool, and we said, there's going to be a very rigid process for changes to the system. And we have a regular process where we vet ideas and we think about the overall utility of any given suggestion, and if it makes sense broadly across the user base, we'll go ahead and work with TCDI to implement that kind of a modification to the system. If it doesn't, we won't. And we've found that over time that has been a great benefit in controlling both the cost of operating one of these systems as well as its utility, because it can grow in unexpected ways if you don't stay on top of it and become potentially less useful across the board than it otherwise might be.
Ellen, any experiences that you'd like to talk about that you do differently next time?
Yes, I've had at least one experience with a completely well-intentioned client who envisioned their legal knowledge management system. Quite frankly, they did a great job envisioning it, understood each of these points that we talked about, and had even projected out how they were going to do the return on their investment. The challenge there turned out to be that they really didn't bring their outside counsel into the loop and into the conversation early enough. And they ended up not realizing their return on investment, because to make a system like this work well and to actually save money and to get the full benefits, your law firms need to be full participants and completely bought in, and they need to use it and use it aggressively and not worry about it, not feel like it's a threat. They need to feel like it's a tool that makes them better lawyers and makes them more effective in their jobs. And in that instance, I would say, as a best practice, as early as possible, the law firms who are going to be using the system need to at least have some voice or some input, subject to the kinds of limits that Mike just talked about, because you can't customize it 50 different ways for 50 different law firms. But they need to be in the circle early and often, because it needs to be useful to them, and it needs to be something that they're willing to use in order to actually achieve some of those cost savings. So that's a key point that I saw a major stumbling block on for at least one client, and what ended up happening was a wonderful system really wasn't used. The second point was, in a completely different scenario, I had a client really want a great legal knowledge management system, and when we got into it, it turned out, quite frankly, they just didn't need it. The litigation had a different resolution that was going to come about through the timetable of the life cycle of the case, And as much as I would have loved to be able to do a great case management system for them, the truth is sometimes you have to also say, I don't need it in this scenario, and be willing to make that call as well, because you don't need this for every case and every piece of litigation that might come into your firm or might come into your company.
So I'm going to move forward to the next and last agenda topic, since we only have a few minutes remaining, and I will start by asking Mike and Ellen, where do you expect litigation management technology to grow and change, and is there one must-have thing that you wished it did for you today, other than try your cases for you? Wish that it did for you today, that you've asked to be provided in the future? Just really, how do you think things are going to evolve? Mike, why don't we start with you?
Sure. I think the evolution is. I think we are in the midst of the evolution of far better document reading. The ability to understand a document and thereby, in an automated way, populate certain fields of material or to summarize certain information in a way that doesn't require human intervention. This is a tool that is used by humans. This is not a tool that stands alone and you just simply ingest documents and it does all the things necessary. There's still a requirement for some real meaningful human interaction. I think over time the technology will improve to the point where there'll be less need for that. It'll never go away, I think, because judgment is still necessary when thinking about how to classify and categorize certain bits of information and how it connects to other pieces of information. But I do think that's the evolution that I see happening and that I look forward to accelerating, because I do think it will drive even more cost out of the system. I know internally, the team I manage, I have a significant amount of headcount devoted to operating in this tool every day, and I would likely have less over time as some of the auto-population and automatic categorization of information improves.
So Kara and Ellen, anything from you? Where do you think it's going to evolve to? And what is there one thing that you wished it now did for you?
Well, Tim, I'd like to see new and advancing tools for predictive analytics. We have a lot of information about cases and judges and law firms and outcomes in cases that if we had a more robust predictive analytics tool, and I think they're on the horizon, I think they're there. I think with machine learning and AI, it's going to just be the natural next step. There are a lot of systems out there now that are already talking about doing this, but I'd like to have additional tools in here that help us not only with reports of existing information, but predictive reports, trends analysis, case comparisons, helping differentiate and understand outcomes analysis. We do a fair amount of that manually now, and more tools to help with that would be invaluable.
Yeah, and I agree with that. And that would be the biggest impact that I think is going to happen to litigation management tools in the very near future, but definitely far-reaching as well. I mean, AI exists to some degree in most litigation management platforms today. Data mining and classification algorithms are the tools that are allowing for the powerful visualizations that we were showing before, that dashboarding, the interactive connectivity, the clustering, the grouping, the auto-classification of similar documents. I think that's only going to extend, as Ellen said, as these tools become more mainstream. I would envision using conceptually similar research from previous similar cases to create strategy for your current case. Ellen mentioned creating detailed case, plaintiff, or maybe judge analysis trends, maybe identifying bellwether cases. I think AI is going to be able to do a lot more trend spotting for us. And since all that data is in one location, just adding different technology or visualizations or graphics in order to create new stories and tell new stories and, spot those trends for us. I think that's really the direction that litigation management tools are going.
So I think that we are out of time, and what I'd like to do is thank Ellen and Kara and Mike for participating, and thanks to EDRM for hosting us, and to our audience for participating. And I look forward to being on a future EDRM webinar. Thank you very much.